Federal Motor Carrier Safety Administration Part 384, State Compliance with the Commercial Driver License Program. Subpart A, General 101, Purpose and Scope. 103, Applicability. 105, Definitions. 107, Material Matter incorporated by reference. Subpart B, Minimum Standards, Substantial Compliance with the States. 201, Testing Procedures. 202, Testing Standards. 203, Driving while under the influence. 204, CLP CDL's Issuance Information. 205, CDLIS Information. 206, State Record Checks. 207, Notification of License. 208, Notification of Disqualification. 209, Notification of Traffic Violations. 210, Limitation on Licensing. 211, Surrendering Old Licenses. 212, Domicile Requirements. 213, Penalties for Driving Without Proper CDL. 214, Reciprocity. 215, First Offenses. 216, Second Offenses. 217, Drug Offenses. 218, Second Serious Traffic Violation. 219, Third Serious Traffic Violation. 220, Probable Driver Point System Information. 221, Outer Service Regulation, Intoxication Beverage. 222, Violation of Outer Service Orders. 223, Railroad Highway Grade Crossing Violation. 224, Non-Commercial Vehicle Violation. 225, CDLIS, Driver Record Keeping. 226, Prohibition Masking and Convictions. 227, Record of Digital Image Photograph. 228, Examiner Training and Record Checks. 29, Skill Testing, Examiner Auditing, Monitoring. 230, Entry Level Driver Certification. 231, Satisfaction of State Disqualification Requirements. 232, Requirement Time of the Record Checks. 233, Background Record Checks. 234, Driver Medical Certification Record Keeping. 235, Commercial Driver License, Drug Alcohols Clearinghouse. 236, Entry Level Driving Training Provider Notification. Subpart C, Procedures Determining State Compliance. 301, State Substantial Compliance General Requirements. 303, Reserve. 305, State Certification Federal Official Years after 1994. Federal Motor Carrier Safety Administration Programs View State Compliance. 309, Resolve the Compliance Determination. Alright, Subpart D, Consequences of State Noncompliance. 401, Withholding Funds above the Noncompliance. 403, Prepared Availability, Effective Compliance, Noncompliance. 405, Decertification of State CDL Program. 407, Reserve. 409, Notification Compliance. Alright, Subpart 8, General 384-101, Purpose and Scope. The purpose of the ensure for the state to comply with the provisions through 12,009A, the Commercial Motor Vehicle Safety Act of 1986. Scope of this part includes the minimum standard of the action state must take the substantial compliance with each of the 22 requirements of Title 49 U.S. Standard Code 31311A. Establish procedure determining the made of such compliance with by state. Specify the consequence of state compliance. 384-103, applicability. The rules apply to part apply with the state. 384-105, definition of the part. 383, title apply with this part. Exact whether the otherwise specialized noted as used in this part. CDLIS motor vehicle record means a report generated with the CDLIS track of a record meetings requirements of access CDLIS commercial driver license and information provided with the state authorized within 384-225A 3 and 4 subject to the provisions of the Driver Privacy Protection Act 18 United States Code 2721 through 2725. Issuance means initial issuance, renewal, upgrade of the CLP non-domicile CLP for the initial issuance, renewal, upgrade, transfer of the CDL non-domicile CDL described in 388-373 of this chapter. Subchapter license entity means the agency, state government authorizing the issue driver's license years of non-compliance means the federal official years during which the state fails to submit timely certification as a part prescribed in Subpart C of this part. State does not meet one of the more standards of Subpart B of this part made final determination of Federal Motor Carrier Safety Administration 384-307C of this part. Alright, 384-107 the matter incorporated the reference. Incorporating the reference of the parts include the reference term of the matter of the material, the text of the material that must include the regulation contained within the part of the materials are hereby made a part of the regulation of the part of the director of the Office of the Federal Register. Approve the materials incorporated reference in accordance with Title 5 U.S. Standard Code 552A with the Title 1 CFR Part 51. Material subject to change with only specific versions. Approved by the Director of the Office of the Federal Register, specified with the regulations incorporated, the material incorporated as it exists on the date of the approval. The notice of any of the change of these materials will be published in the Federal Register. All the materials incorporated by the reference available for the sources listed below available to the Inspection Department of Transportation Library, 1200 New Jersey Avenue, Southeast Washington, D.C. The telephone number there is 202-366-0746. The documents also available to inspection copying provided with the Title 49 CFR Part 7. These available to the inspection of the National Archive Record Administration and their website. The American Association of Motor Vehicle Administrators, or AAMVA, 4301 Wilson Boulevard, Suite 400, Arlington, Virginia, 22203, 703, 522, 1300, Commercial Driver License Information System. State Procedures Manual Release 5321, August 2013, incorporated reference approved, and 384-225F and 384-231D and 2 is reserved. Alright, subpart B, minimum standard substantial compliance by state with the test 384-201 testing program. The state shall adopt the administrator of the program testing and ensure the fitness of the person of the operator of the commercial motor vehicle in accordance with the minimum federal standards contained in the 383 of this title to obtain the Federal Motor Carrier Safety Administration approved state testing system reference of 383, 131, 383, 133, and 380, 135. State driver license agencies over the contact of the Federal Motor Carrier Safety Administration, CDL Division, 1200 New Jersey Avenue, Southeast Washington, D.C. 380-4202 standards. No state shall authorize a person to operate with the commuter. I already did. All right. Commercial motor vehicle unless each such person passes knowledge of driven class driven skill for the test operation commuter motor vehicle commercial motor vehicle in accordance with the part 383 of the title 384-203 to driving while under the influence. The state may in fact enforce the licensing sanctions disqualification prescribed in 383-51B with the subchapter driving the commercial motor vehicle with a 400 of alcohol concentration. Nothing in this section shall contribute with the required state to apply with the criminal other sanctioned drivers under the influence of the person found to have operated the commercial motor vehicle in alcohol concentration of 400s, except in license sanction, including suspension, revocation, cancellation, state and acts enforcement of the through license and transaction disqualification prescribed in 388-351B with the subchapter for driving the commercial motor vehicle with 400th alcohol concentration. Give the full faith credit of the disqualification commercial motor vehicle. The drivers or other states shall deem the substantial compliance with section 1209A3 with the Commercial Motor Vehicle Safety Act of 1986. 384-204 CLP and CDL issuance information. General, the state of the authorized the person with the copper with the commercial motor vehicle only with the issuance of the CLP or the CDL, unless the exemption of 383C and D applies, which contains a minimum of the information specified in 383 subpart J of the subchapter. Exemption training. The state may authorize the person who does not have the CDL valve of the type of the vehicle to which in training and occur for the undergo the behind the wheel training of the commercial motor vehicle only by means of the CLP issued and using in accordance with 383 and 225 of the subchapter. All right, confixiation of the CLP with the CDL pending an enforcement of the state may allow with the CLP with the CDL holder use the CLP. CDL is held in trust by the state and any other state with the course of enforcement of the motor vehicle traffic code by who has not been convicted of disqualification offense of 383-51 subchapter based on such enforcement to the driver of the commercial motor vehicle while holding the date receipt with such CLP and CDL. Alright, 384-205, C is Commercial Driver License Information System. Before CLP and CDL to any of the person state must, within the period of time specified in 384-232, perform the check of the Commercial Driver License Information System in accordance with the 383-73B32 with the subchapter based on the information issued with the license in case of the adverse information promptly implement disqualification license limitations, denials, and penalties that are called for any applicable section of the subpart 384-206 state record checks. Issue state records before issuing, renewing, upgrading CLP, issuing the renewing, upgrading of the transfer of CDL to any of the persons or state driver's license record. State record must be within the period of time specified in 384-232. Check of the own driver's list. Driver's record to file the driver record of the person in accordance with 383-73B31 of this chapter for the driver. The certified that his or her driver is not accepted by the interstate with commerce according with the 383-71B11 of this chapter. Medical certification status information of the person of the commercial driver license information system driver record. Based on the findings of its own state record check, the state record must do one of the following appropriate: issue, renew, upgrade, transfer application CLP or CDL. In the event the state obtains adverse information regarding application, promptly implement disqualification, licensing, limitation, denial of penalties that are called with any applicable selection with the subpart 3. In the event of no information regarding driver self-certification with the driver type required with the 383-71B1 with the driver was required in 383-71H, the certified but the medical certification status of the individual non-certified state must deny CDL action requested by the applicant, initiate the downground CDL if required. 383-7304 of this chapter. B. Other state records before the initial transfer issuance of the CLP or the CDL to the person before renewing the upgrading the CLP to the CDL. They have, and any of the person issuing the state must require applicant to provide the name of the state with where the applicant with the previously licensed operated with any type of the motor vehicle during the previous 10 years. When the time period specified in 384-232 is request for the complete driver's record with all states where the applicant was licensed within the previous 10 years operated with any type of the motor vehicle. The state received the request for the driver record of the pursuing person currently previously licensed in the state must provide the information within 30 days. Based findings of the other state records for the issuing state, but the must indicate the adverse information regarding the applicant, promptly implement disqualification, licensing, limitation, denial, penalties that are all called in applicable sections of this part. Alright, 384.207, notification of license with a period defined in 383.73H for the subchapter of the state must notify the operator of the commercial driver license information system of the CLP or the CDL issuance, notify the operator of the commercial driver license information system of the chamber of the driver identification information, in this case transfer, issuance, to implement the change of state of the record transaction specified by the operator of the commercial driver license information system with the conjunction with the previous state record of the operator of the commercial driver license information system. Alright, 384.208, notification disqualification. No later than 10 days after the disqualifying of the CLP of the CDL holder licensed in another state disqualified outstate of the CLP CDL privilege to operate with the commercial motor vehicle at least 60 days with the state of the must notify the state of the issued license disqualification. Notification must include the disqualification violation, result of the disqualification, revocation, suspension, cancellation notification, and the information provided must be recorded with the commercial driver license information system driver record. 384.209, notification traffic violation. Record notification with respect with the CLP, the CDL holders, whenever the person with the CLP or the CDL in another state convicted of the violation of any of the state or local law relating to the motor vehicle traffic control other than parking in a vehicle defect violations, any type of the vehicle, the licensing at the state in the conviction occurred with the must have to notify the license at either the state with the driver's license in the conviction of the time of the period established in paragraph C of this section. Whenever a person holds the foreign commercial driver's license convicted of the violation of any of the state of the local related law relating to the motor vehicle, the traffic and control, other than parking vehicle, weight with the vehicle defect, the violation, any type of the vehicle, limited licensing, at either the state in which the conviction occurred, with the must report the conviction on the federal conviction within the withdrawal of the database. Required notification with respect to the non-CDL holders whenever the person does not hold the CDL who is in license for the driver then by another state with the conviction of the violation of the commercial motor vehicle of any of the state local law relating to the motor vehicle traffic control other than parking violations of the license at neither state in which the conviction occurred, but must notify the licensing at neither of the state where the driver license and conviction within the time period established in paragraph C of this section. Whenever a person in a foreign country with an unlicensed holds the foreign non-commercial driver license convicted of the violation of commercial motor vehicle within any state local law relating to the motor vehicle traffic other than parking violation, the license is at neither state in which the conviction occurs, must report the conviction on federal conviction withdrawal database. Notification of traffic violations must be made within 10 days of the conviction. Alright, 384.210 limitation on licensing. State must knowingly issue the CLP, CDL commercial special license permit, including the provisional temporary license permitting a person to drive a commercial motor vehicle during the period in which the person is disqualified operating with a commercial motor vehicle. The disqualification defined in 385.3 with a subchapter under the provision 383.73J or 384.231 B2 of the subchapter CLP and CDL holds the non-commercial driving privileges has been disqualified. Any type of the driver's license by any such person disqualified in the state of the driver's license, any state local law related to the motor vehicle traffic control other than parking, vehicle weight, and vehicle defect violations. 384.211 surrendering old licenses. The state may only initially upgrade with the transfer of the CDL into the person unless such a person first surrenders any previously issued driver license CLP. Alright, 384.212, the domicile requirements. The state may issue the CDL of the CLPs to only person who they have the state with the state domicile of the defined in 383.5 of the subchapter, except that the state may issue the non-domicile CLP CDL under the conditions specified in 383.23b to 383.71f, 383.73f. The subchapter, the state must require any of the person holding CDL issued in another state to apply the transfer of CDL from state within 30 days of the established domicile state that is specified in 383.71c of the subchapter. Alright, 384.213, state penalty of the driver of the commercial motor vehicle. The state must impose the drivers of commercial motor vehicles appropriate civil and criminal penalties that are consistent with the penalties described in 383 subpart D of the subchapter. 384, reciprocity. The state must allow all the person operating with a commercial motor vehicle state with a not disqualified operating the commercial motor vehicle that holds a CLP or CDL that is issued to him or her or his or her state or jurisdiction domiciled in accordance with part 383 subchapter, not disqualified, valid under terms of of 383 subpart F, the subchapter of the type of the vehicles being driven. 384-215, first offense, general rule, the state of the disqualified of the operating of the commercial motor vehicle, each person convicted is defined in 383-5 with the subchapter and state of the jurisdiction disqualifying offenses specified in items 1 through 8, table 1, 385-51, subchapter no less than 1 year. Special rule of the hazard material offense of the offense under paragraph 8 of the section occurred while the driver was operating vehicle transportation hazard material that defined in 383-5. The state shall disqualify the person no less than 3 for no less than 3 years. All right, second offense, 384-216, second offense, general rule, the state must disqualify the line operating with a commercial motor vehicle, the person convicted of the defined in 383-5, subchapter, in any state, jurisdiction, subsequent offenses described in Table 1 and 383-51, subchapter, special rules on certain lifetime disqualification drivers disqualified for life under Table 1 and 383-51 before and reinstated after 10 years of the driver's state residency if the requirements of 381-51A 6 has been met. All right, 384-217, drug offense. State must disqualify the operator with a commercial motor vehicle for life any of the person which was convicted and defined in 385-5 of the subchapter any state jurisdiction for offense of using commercial motor vehicle, or in the case of CLP, CDL holder, commercial motor vehicle, non-commercial motor vehicle, commissioning a felony described in item 9 of the table of 1, 383-51, subchapter the state shall not apply the special rule 384-216B with lifetime disqualification imposed with controlled substance felonies detailed in item 9, table 1, 383-51, subchapter. 384-218 was the second series of traffic violation. State must disqualify operator with a commercial motor vehicle the period not less than 60 days to each of the person in the 3-year period convicted of the defined in 383-5 of the subchapter in any of the state of the jurisdiction 2 series traffic violations specified in Table 2, 385-51. 384-219 third series traffic violation. State must disqualify the operator with a commercial motor vehicle the period not less than 120 days each person who is in the 3-year period convicted of the defined in 383-5 of the subchapter in state of the jurisdiction of 3 series traffic violation specified in Table 2, 385-51. Disqualification must be in addition with any of the other previous period of disqualification. 384-220 problem driver pointer system information. Before issuing CLP CDL to any of the persons, state must within the period of time specified 384-232 perform a check with the problem driver pointer system in accordance with the 383-73B33 subchapter based on the information promptly implementation of the disqualification, license, limitation, and or penalty that are called in any applicable section of the subpart. All right, 384-221 out of the regulation, intoxication, beverage sale. The state shall adopt and enforce the operator of commercial motor vehicle defined 383-5, 390F of the title provision of the 392-25 and 392F, 392-5 A and C with the title of the accordance with the Motor Carrier Safety Assurance Assistance Program that defined in Title 49 CFR Part 350 applicable to policy and guidelines. 384-222, the violation of the out-of-service orders of the state must have to enforce the law and regulations applicable to the driver of the commercial motor vehicles and their employer that defined 383-5 of the subchapter must meet the requirements of the 383-37D in the Table 4, 383-51, and 383-53B of the subchapter. 384-223, railroad highway grade cross violations of the state must have the enforcement law and regulations applicable to commercial drivers and employers and defined 383-5 of the subchapter meet the minimum requirements of 383-37E, Table 3, 383-51, and 383-53C of the subchapter. 384-224 non-commercial motor vehicle violations. State must have the enforcement law regulations applicable to the driver of the non-commercial motor vehicle defined in 383-5 of the subchapter will meet with the minimum requirements of Table 1 and Table 2 a 383-51 of the subchapter. All right, 384-225 commercial driver license information system to driver record keeping. The state there must have the CLP or CDL holder posted with the maintained with the part of the commercial driver license information system driver record. All conviction, disqualification, other licenses, actions of the violation, any state, local law relating to motor vehicle traffic other than parking in vehicle way with the vehicle defective violation committed to any of the type of the vehicle, the following medical certification status information. Driver self-certification, type of the driver, operation provided in accordance with 383-71B1 of this chapter, information for the medical certificate record keeping in accordance with 383-730 of the chapter. B. A person required for the CLP with the CDL required to maintain the part of the CDL license information system record and the conviction of the disqualification of the license action violation any of the state, local relating motor vehicle traffic control with other parking vehicle way with the vehicle the defect violation committed while the driver was operating commercial motor vehicle. The making CDL commercial driver license information system driver record information required the section available to the user and designation paragraph of either section of the authorized agent within 10 days of receiving the conviction with the disqualification information from another state or the date of the conviction if then occurred occurred with the same state with retaining the commercial driver license information system driver record, all conviction, disqualification, and or other licensing action violations at least 3 years longer than required. 384, 231D, only allowing the following user authorized agents to receive the designated information. 1 states all information, all of this commercial driver license information system, driver record, Secretary of Transportation, all of the information of the commercial driver's license information, driver records, driver, all information of the driver, the commercial driver license information system, driver record, obtain the commercial driver license information system, motor vehicle record from state according procedures. All right, motor carrier and prospective motor carrier with any notification, any after notification, all information for the driver, the protective driver, the commercial driver license information system for the driver, the record obtained, the commercial driver license information system, motor vehicle record with the state of the accordance for the is into its procedures. Ensure the content report provided user authorized paragraph E with the section for the commercial driver license information driver record comparable the report would be in generated with the commercial driver license information state to state request for commercial driver license information system driver history to define and commercial driver license state procedure incorporated with the reference C with 3084 107B with the must include the medical certification such as ASS information driver in paragraph A2 of this section does not preclude authorized user for the request and commercial driver license information system state driver status. Alright, 384, 226, prohibition, masking, conviction. The state must not mask or defer the imposition judgment, allowing the individual entry of the diversion program that would prevent the CLP, CDL holder conviction, any violation, any type of the motor vehicle to state of the local traffic control other than parking vehicle weight, vehicle defect violation appearing on the CDL's commercial driver license information system, driver record, whatever the driver is convicted offense for the committee with the state, with the driver license in another state. Alright, 384, 227, the record with the digital image of the photograph of the shape must record a digital color image of the photograph of the black and white laser for the engraved of the photograph, the capture of the part of the application process of the placing the license document of every person with the issue with this commercial driver's license required under 383, 153, the digital color image of the photograph of the black and white laser engraved of the photograph must be either made with the part of the driver history or be linked with the driver history separate file. Check for the digital color image of the photograph, black and white laser, the engraved photograph on the record of the CDL applicant holder of the person here for the renewal of the upgrade with the transfer of the CDL when a duplicate of the CDL is issued. Check for the digital color image of the photograph of the black and white laser engraved of the photograph recorded when the CLP application holder of the appears on the person issued the renewal upgrade of the CLP with the duplicate CLP is issued. If no digital color is photographed in black and white laser engraved photograph exists on the record of the shape, must check with the photograph and an image on the base license presented with the CLP CDL issued application. Alright, 384, 228, the examiner training with record checks. For all state and third-party CDL tests, examiner the state must meet with the following 10 requirements. Establish examiner training with standard with initial refresher training with the CDL test, examiner fundamental understanding of the object with the CDL testing program with all the knowledge and skill necessary for the serve of the CDL testing examiner as if the jurisdiction meeting the federal CDL testing requirements. Regardless state knowledge skill test, examiner successfully completing the formal CDL test, examiner training course examination before certifying them to administrative CDL knowledge, skills, and tests. Training course of CDL knowledge of the text examiners must cover at least the following 3 units of instruction: introduction to CDL licensing system, commercial motor vehicle safety act of 1986, driver coverage, drivers covered in the CDL program, CDL vehicle classification, CDL endorsement restriction, overview of CDL test, CDL testing, classification, endorsement of different examination represented vehicles, validity, reliability test, maintenance knowledge test, general knowledge test, specialized knowledge test, selecting appropriate test forms, knowledge test, administrative the training course for the CDL skills test examiner must cover at least the following 5 units of the instruction: introduction to CDL licensing system, commercial motor vehicle, the Safety Act of 1986, the driver covered in the CDL program, CDL vehicle classification, CDL endorsement restriction, overview of CDL test, classification, endorsement, different examination, representative vehicle, validity, reliability test, maintenance vehicle inspection test, test overview, description, safety review, safety rules, test score, procedure scoring, standards, calculating final score, basic control skills testing, setting up basic control skills course, descripting safety rules, general score, procedure, administrating the test, calculating the score, road test, setting up the road test required maneuvers of administrating road test, calculating the score, requiring all third-party skill test examiners to successfully complete a CDL test examiner training with the examination before certification. Administrative CDL skills of the training course must cover at least 5 units of the instruction in paragraph D. This section. Requires state and third-party CDL examiner to successfully complete the refresher training course examination every 4 years to maintain CDL test examiner certification. The refresher training course must cover at least the following: the CDL's knowledge of the test examining 3 units of the training that described in paragraph C of the section CDL skills and test examiner, 5 units training described in paragraph D of the section any state specific for the material of the information related to administrative CDL knowledge and skills and tests, the new federal CDL the regulations under the administrative tests and result of the new safety-related equipment of the vehicles, complete nationwide criminal background check to all skills test examiners prior to certifying the administered CDL skills test, complete nationwide criminal background checks to all the state and third-party test examiners of the time hiring, complete nationwide criminal background checks to any of the state and third-party current test examiners who had not nationwide criminal background criteria that non-passing criminal background check must include at least the following: any felony conviction within the last 10 years of conviction involved with the fraudulent activities, maintaining records, resolve of the criminal background, resolve of the CDL examiner, the training, the certificate, with the of the CDL test examiners, resigned of the certification administrator of the CDL testing, all testing equipment that does not successfully complete the required refresher training every 4 years. 8 units of the training that described in paragraph CD and 4, C and D of the section supplemented with the state-specific material, the information related to administering CDL knowledge and skills and tests. 384-229, skill test examiner auditing and monitoring to ensure the integrity of the CDL skill testing program. The state must at least once every 2 years conduct an unannounced on-site inspection of the third-party tester of the examiner's required. Records include in comparison with the CDL skill of the test results of the applicant with issuing the CDL with the CDL scoring sheet that maintained with the third-party tester files. At least once every 2 years, the conduct, convert, and over monitoring the examination performed in the state with the third-party CDL testing examiner. Establish, maintain a database, track, and pass-fail rates of the applicants tested in each state with third-party CDL test examiner in order to focus on the over and monitoring of the examiner over the usually high pass or failure rates. Establish, maintain database for the third-party tester of the examiners, which for the minimum track for the day the result of the audit of the monitoring action for the state. Day of the third-party tester were certified with the state with the name and the identification of the number of each of the third-party CDL test examiner. Establish and maintain the database of all state CDL skills examiners with a minimum track of the date for the result of the monitoring action with the state with the name and the identification number of each of the state CDL skills examiners. And establish, maintain the database of track skills tests administrator with each of the state with the third-party CDL skills test examiners identification number. All right, 384 to 230, entry-level driver certification. Beginning on February 7th, 2020, state must comply with the requirements of 383, 73, B32, and B10. E8, verify the application complete with the training prescribed in subpart F of the 380. The state may issue commercial driver license issuance obtained with the CLP before February 7th, 2020. Have not complied with the subpart F of the 380 with the subchapter as long as they have obtained the CDL before the CLP with renewed the CLP expires. A state must issue the CDL to the individuals to obtain the CLP on or after the February 7th, 2020, unless they comply with the subchapter, subpart F of the part 380 of the subchapter. All right, 384 to 231, satisfaction state disqualification requirement act with the provision 384, 203, 206B, 210, 213, 215, 2 through 219, and 221 through 224, and 231 of this part applied to state licensures of the person of effective with the provision of 384, 210 with the part apply with the name of the state of the person making the applicant with the transfer of the CDL. Required action of the CLP, the CDL holder state may satisfy the requirements of the subpart of the hope of the state to disqualify the person hold of the CLP CDL by a minimum disqualification. Person CLP, the CDLF, CDL, the applicable period of disqualification. The person required to have the CLP or CDL state must satisfy the requirements of the subpart of the state with the disqualified the person required to have the CLP CDL who was convicted of an offense for the necessitating disqualification under the 383-51 subchapter minimum. State must implement limitation licensing provider provision 384-210 over the time record. Keep the requirements of the paragraph C and D of the section also to prevent the such a person legal of obtaining CLP CDL from any state during the applicable disqualification period specified in the subpart. Required timing, the state must disqualify the drivers as expeditiously possible. Record keeping the requirements of the state must conform with the requirements of the commercial driver license information system. State procedures incorporated the reference to 384-107B. The requirements for the include the maintenance of the stuff for the driver record, driver the identification to have the commercial driver license information system. The Federal Motor Carrier Safety Administration finds are necessary to implementation enforcement of disqualification call in 384-215 through 219 and 384-221 through 224 of this part. All right. 384, 232 required timing of the record check for the state. Perform the record check for the prescribed in 384, 205, 206, and 220 no earlier than 10 days prior to the issuance of the license before the October 1st, 1995. The license issued September 30th, 1995. Of the state that shall perform the record checks no earlier than 24 hours prior to the issuance of the license issued. The driver who does not currently possess a valid CDL from the state within no earlier than 10 days prior to the issuance of all of the other drivers. 384, 233 background record check. The state shall comply with the Transportation Security Administration requirements concerning the background check with the driver seeking to obtain the renew, transfer, upgrade, as a material endorsement, Title 49 CFR 1572, with the extent of the provision imposed with the requirements of the state. The state shall comply with each of the requirements, Title 49, 383, 4141, 384, 234 of the driver medical certification record. Keep the state must meet the medical certification record requirements of 383, 782, 7, B5, C, 8, D8, D8, E6, and O. All right, 384, 235, commercial driver license, drug and alcohol clearinghouse beginning January 6, 2020. The state must require information of the clearinghouse in accordance with the 383, 73 of this chapter. 384, 236, entry-level training provide notification. The state must meet with the entry-level driver training provider and notification requirements of the 383, 73P. Or subpart C, procedure for determining state compliance. 384, 301, substantial compliance with general requirements. To be in the substantial compliance with the Title 49 U.S. Standard Code 31311A, the state must meet each every standard for the subpart B with the parts meet with the demonstrate the combined effect of the statute, the regulation, administrative procedure, practice, organizational structure, internal control mechanism, resource assignments, and facilities. Equipment and personnel with enforcement practice of the state must come into the substantial compliance with the requirements of subpart B with the part with the effects of the subpart September 30th, 2002, as soon as that practical unless otherwise specified, provided with this part no later than September 30th, 2005. Exemption the state must come into the substantial compliance with the Title 49 CFR 383, 123 no later than September 30th, 2006. The state must come in substantial compliance with the requirements of subpart B with the parts of the effect of the September 4th, 2007, as soon as practical unless otherwise specifically provided in this part no later than September 4th, 2010. The state must come into substantial compliance with the requirements of subpart B with the part effective January 30th, 2009, as soon as practical no later than January 30th, 2012. The state must come into substantial compliance with the requirements of subpart B with the part effective October 27th, 2010, as soon as practical no later than October 20th, 2013. The state must come into substantial compliance with the requirements of subpart B of the parts effective July to 8th, 2011, and April 24th, 2013, as soon as practical, unless otherwise specified, especially provided with this part no later than July 8, 2005. The state must come in the substantial compliance with the requirements of Subpart B of the part effective December 5, 2011, and soon with the practical no later than January 30th, 2012. Alright, 8. The state must come into substantial compliance with the requirements of Subpart B with the parts effective of January 3rd, 2012, as soon as practical no later than January 3rd, 2015. The state must come into substantial compliance with the requirements of Subpart B with the part of the 383 with the subchapter of the effect of June 22nd, 2015, as soon as practical unless otherwise specifically provided with the part of no later than June 22nd, 2018. The state must comply with substantial compliance with the requirements of Subpart B of the Part 383 of the chapter of the after effects of December 12, 2016, as soon as practicable, unless otherwise specified, provided in this part no later than December 12, 2019. 384, 303, Reserve 385, and 384, 305. Stating certification federal official years, official year 1994. Certification requirements prior to January 1st of federal official year of the 1994. Each state review the complying with the part with the certified with the Federal Motor Carrier Safety Administration prescribed the paragraph of the B section certification submitted with the sign of the original four copy of the Division Administrative State Director Office within charge of Federal Motor Carrier Safety Administration located in the state located in that state. Certification content of certification consists of the statement of the governor, state with the official designated of the governor, reading as follows: I am the name certified in the official position, title of the state of the Commonwealth. They hereby certify with the Commonwealth the continuous being substantial compliance with all the requirements of Title 49 U.S. Standard Code 31313A, defined in Title 49 384 301, since the first and the day of the first Thursday of the current official year, with the contemplated with no change of the state regulation and administrative procedures or an enforcement thereof that would affect the substantial compliance through the last day of the current federal official year. Alright, 384, 307. Federal Motor Carrier Safety Administration Program reviews the state compliance. Federal Motor Carrier Safety Administration Program reviews each state with CDL program must each of the review determining whether or not the state meets the general requirements. Substantial compliance with 384, 301. Statement that must cooperate the review that provide information requests for the Federal Motor Carrier Safety Administration. Preliminary Federal Motor Carrier Safety Administration determination state response after the review preliminary determination either state has not been submitted the required annual self-certification or that the state does not meet one of the more minimum standards of substantial compliance under the subpart B, the state will be informed accordingly. Reply, but the state will have up to 30 calendar days to respond. Preliminary determination. The state with the reply must explain with the corrective action that either implemented in attempt to implement the corrective deficiencies decided with the notification alternative, or the Federal Motor Carrier Safety Administration preliminary determination is incorrect. The state must provide the documentation corrective action required by the agency. Corrective action must be adequate to correct the deficiencies noted in the program review implemented on the schedule mutually agreed upon with the agency and the state, and upon request by the state with informal conference provided during this time. Your final Federal Motor Carrier Safety Administration determination reviewing the timely response date of the preliminary determination. The final determination is made by the state. If it is not compliance with the affected standard, the state will notify of the final determination. Making the final determination, the Federal Motor Carrier Safety Administration will take into consideration corrective action, either implemented plan to implemented in accordance with the mutual agreed upon schedule. States' right in judicial review. Any state aggrieved by an adverse decision under this section may seek judicial review in Title V U.S. Standard Code, Chapter 7. Alright, 384, 309, result of the compliance determination state shall determine the non-substantial compliance with the Title 49 U.S. Standard Code 31311A with any official year with which it failed to submit the certification prescribed in the subpart does not meet one with more of the standard subpart B with the part established final determination Federal Motor Carrier Safety Administration 384, 307A D with the state shall have substantially compliance with the Title 49 U.S. Standard Code 31311A for any official year with neither evaluates if in the paragraph A with the section occurs. Alright, subpart D, consequences of state of non-state non-compliance. 384-401, withholding funds of the base for the non-compliance following the first year of the non-compliance amount with the 4% of the federal aid highway funds required for the proportion of any of the state under each for the section 104B1, B3, B4, Title 423 United States Code shall withhold the state of the first day of the official year following the state of the first year of the non-compliance under the part following second and subsequent years of the non-compliance with the amount up to 8% of the federal aid highway required for the portion to any of the state of each for the section 104B1, B3, B4, Title 23 United States Code should be withheld in the state of the first official year following the such of the second and subsequent years of the non-compliance under this part. 384-403 availability of funds withheld with the non-compliance federal aid highway funds within the state under 384-101 and the subpart not with thereafter available in portion of the state to the state. Or 384-405, decertification of the state CDL program prohibition of the CDL transaction. Administrator may prohibit the state fund with a substantial non-compliance with performing any of the following CDL transaction: initial insurance renewal, transfer, upgrade. Conditions considering making the decertification determination. Administrator will consider but not limited to the following 5 conditions of determining whether the CDL program of the state with the substantial non-compliance shall be decertified. State computer system with not check with the commercial driver license information system that ran the or national driver registry problem. Driver pointer system added the required of the 383-733, subchapter issuing, renewing, upgrading, CLP issuing, renewing, upgrading, transfer of the CDL. The state does not disqualify the drivers convicted of the disqualifying offense for the commercial motor vehicle. The state does not transmit the conviction of the out-of-state drivers to the state with the driver's license. For the driver's license, the state does not properly administer the knowledge and the skill of the test of the CLP, CDL applicant. The driver of the state fails to submit the correction of the action plan with the substantial compliance deficiency, fails to implement the corrective action plan within an agreed time frame. The standard of the considering the deficiency described in paragraph B of the section must affect substantial number of the either CLP, CDL applicants for the driver's decertification preliminary determination administrative fine by the state. The substantial non-compliance subpart B of this part with the indicating of the factors specified in paragraph B of the section. Among the other things, Federal Motor Carrier Safety Administration will inform the state that has been preliminary determination of the non-compliance with the state CDL program, may therefore decertify any response of the state, including factual or legal arguments of the corrective non-compliance, but submit the 30 calendar days after the receipt of the preliminary determination. Decertification final determination, if in all considers all material substance submitted, state in response to the Federal Motor Carrier Safety Administration preliminary determination administrator decides substantially non-compliance exists within the warrants decertification of the CDL program, he or she will issue the decertification order prohibiting the state from issuing CLP CDLs until the site of the administrator determines the condition causing the decertification has corrected. Recertification of the state governing the decertified and his or her designated representative must submit the certification documentation condition using the decertification has corrected. If the Federal Motor Carrier Safety Administration determines the conditions because the decertification has satisfactory corrected, the administrator will issue recertification order, including any of the conditions that must meet the order of the issuing of the CLP CDLs in the state. The slate right the judicial review any of the state will agree with an adverse decision under this section that may seek the judicial review in the Title V U.S. Standard Code, Chapter 7, the validity previously issued in CLP CDLs issued by a state prior to the date issue the prohibition from issuing CLP CDLs in accordance with the provision of paragraph A of this section will remain valid until the state expiration date. All right, 384, 407, the reserve, 384, 409, notification of noncompliance. If the Federal Motor Carrier Safety Administration determined that state that it's not in substantial compliance with the 384, 209, or if the Federal Motor Carrier Safety Administration issued the decertification order prohibiting the state from issuing commercial driver license, Florida Motor Carrier Safety Administration will notify the commercial learning permits of the commercial driver license holders that these actions are published in the Federal Register notice. Notification will advise the commercial driver, commercial learners permits and commercial driver license holders that they must comply with the self-reporting requirements of 383.31a with respect to the convictions obtained with the state until by such time the Federal Motor Carrier Safety Administration determined that the state is substantial compliance. And that was part 383. 383. 384 state compliance for the commercial driver license program.